Welcome everyone. I'm Russell Alexander. I've been practicing law with our team here at Russell Alexander Collaborative Family Lawyers for over 20 years. You can learn more about how we're dealing with COVID-19 on our Divorce and Information Center at russellalexander.com. Without further ado, let's get into today's topic. Divorce Act changes in force at last. It's been in abeyance for almost a year and more than 20 years in the making before that. But the long-awaited changes to the Divorce Act are finally in force. Back in June 21, 2019, the Canadian government passed Bill C-78. It contains a suite of broad and ambitious changes to the existing federal legislation affecting family law, most notably the Divorce Act provisions pertaining to parenting rights and obligations. They were slated to come into force last summer, but were deferred until now due to COVID-19 and the pandemic. At long last, the revisions specific to the Divorce Act are officially in force as of March 1st, 2021, with other changes to follow in stages. Bill C-78 amendments are wide-reaching, but they have a unified theme, promoting the best interests of the child. Going forward is a theme that will permeate the child-related arrangements between separating and divorcing parents, not to mention the court's decision-making. For example, the amendments implement groundbreaking changes to the Divorce Act's non-culture around parenting. It replaces the terms custody and access with more neutral terms like parenting orders and contact orders, respectively. If you're enjoying this video and find it helpful, you can give it a thumbs up or leave a comment below. These changes are more cosmetic. Courts will be able to impose, more than cosmetic, they'll be able to impose tailored directions to the care of a child while avoiding the former winner-loser approach that had been subject to long-standing criticism for its combative and unproductive tenor. This means that the level of parental conflict should be reduced, which of course is better for the child as well. Next, the amendments also give the family courts clear guidance on the factors to be considered when making orders of various types. For instance, when a court is called upon to consider the best interests of the child as part of making an order allocating parenting time as between both divorced parents, it must now consider a detailed list of express factors, including the nature and depth of the child's relationship with his or her parents, grandparents, and other important people in the child's life. The child's upbringing, including linguistic, cultural, and spiritual heritage, and the views and preferences of the child. The other changes brought in by Bill C-78 will be discussed in detail in upcoming blogs and videos and cover important revisions to the law around such topics as mobility involving the children's or parents' right to relocate after divorce, family and violence as especially impacts the child's well-being, reducing poverty especially after divorce or separation, including measures to enforce child support, and making the family justice system more efficient and accessible to participants. To learn more about these changes, you can read our full commentary in the link below. We also have a podcast series and YouTube series coming out on changes to the Divorce Act, which is a 6-part series. Our first one's being released shortly. Leave your comments below if you like this video. If you liked the video and found it helpful, please give us a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.